Hi, this is Curt and welcome to another edition of Fire Law Roundup.
In any event, we're going to Washington, D.C. For those who do or don't know Dennis Rubin, he's only a line in this, so I'm not really going off on him. But
he's not named.
He's a name, yeah. No. Just a point in history in the case. But in any event, so we're going to Washington, D.C. Very interesting because firefighter/EMTs, and I'm going to give you people a little bit of the history that they recite. They have filed a class action saying that they are going to have to work much longer than any other firefighter. And again, I'll explain this to everybody, because they transferred from EMS where they accrued a lot of, let's say, service years towards their defined, I think that was a defined contribution program. And now they've been moved into the firefighters classification, right? So from EMS to fire, and fire has a defined benefit program. And these are very different programs. Defined contribution universally is not a third as good as a defined benefit program. Just to explain why this is such a big deal, defined contribution basically says, listen, we're going to tell you what we put in, but we're not going to guarantee you anything, what comes out. If the market does badly, oh well. Right. But defined benefit says we're defining the benefit. You will know what you get. Those programs are always better. This is a big deal. So what happened is in the 80s, according to the lawsuit, DC Fire had very few white firefighters on the fire side. And apparently, allegedly, right? We're not, Curt and I are not
DC EMS. DC Fire had mostly white males.
Mostly white males.
EMS had mostly minority and some women.
Right, because they claim that people didn't feel comfortable, minorities didn't feel comfortable on the fire side. So they went mostly to the EMS side where they had the defined contribution program. And at some point they said DC Fire needed more firefighters. So they tried to move a lot of EMS personnel to the dual holding of fire/EMS. And there was two big things other than oral promises. There was legislation passed in the city that said, we're going to move you over and you will participate, get all the benefits. What's happened now, 2 years ago, I guess, informally, somebody made a comment high up, and this was in 21, that said, you're not getting the benefits. But now the lawsuit comes 2 years later because there was apparently a formal action taken where they absolutely made clear you're not getting the benefit of moving over. So what happens is the lawsuit says, listen, we've got to work 15 years longer for those who came from EMS to fire than those who are just straight firefighters. And we have to work 15 years longer. So this, again, it's very specific to DC. I can't imagine this ever would happen in any other place again. But that's the suit, and it on its face, it seems pretty legit. Because
I think there's really kind of two arguments that they make in the case, and one is sort of a breach of contract action, that you promised us that if we transition from just single purpose EMS to dual purpose firefighter EMS, that you would treat us as firefighters and you'd give us our seniority. Our seniority would carry over, and our total length of service combined would only have to be 25 years. Apparently now what they've said is they've reneged on that promise, and now they're saying you have to put in 25 years on the fire side. Forget what you put in previously, 25 years on the fire side. So there's alleging a breach of contract, promissory estoppel, all the things that go along with a breach of contract. Here's the other thing. They're alleging race and gender discrimination based on the things that we talked about earlier, that EMS historically in DC had a higher percentage of African Americans and women. For the reasons that they said. And again, I don't know if that's accurate or not, but there was a perception that they weren't as welcome on the fire side, but they were welcome on the EMS side. But they're essentially alleging that there's some race discrimination and gender discrimination in there. And throughout the complaint, if you read the complaint, they make the argument that the firefighters were always treated better than EMS.
The white, predominantly white institution of the firefighters.
And I think that's really, we hear that. I've heard it in other places, but to me, I'm trying to think of a good metaphor for, EMS. EMS is a tough job. I wouldn't want to do it. Okay. Firefighting is a tough job and I love doing it. So, there's a difference there, I think, in your approach. Who's entitled to more pay? Personally, I don't care what EMS gets paid. I don't want to do it. That's just my approach. But there are other people who really love it. I know you did it for a number of years.
Decades,
okay?
yeah.
In Boston and
New Orleans, yeah.
right? Yeah. So hats off to you. But to allege that it's race discrimination or gender discrimination, it's kind of like comparing two jobs, almost like comparing like a prison guard and a police officer, and the prison guards are saying, well, we should get the same as a police officer. Well, maybe you should, but it's not because of race or gender or whatever that you may be getting less. Right. It's a different job. So I think here's
an unnecessary claim.
They filed the claim in federal court, and breach of contract is not going to keep them in federal court.
Correct. And that is the main thrust of this suit.
Exactly. So I think they threw those in, whether they're going to win or not. I see the case potentially getting knocked out on that issue. I guess that's my point, because I think it's a tough case to make that it was race and not any other factor, right? Or gender and not any other factor that led to them being treated the way they are. And if they lose on that, the case gets bounced out of federal court. Now, possibly they can refile in DC has a DC oriented. It still is technically a federal court, but it's considered to be the equivalent of a state court. Right. So I really think that's probably where the case should have been brought, but who knows?
Yeah, and look, all they got to do is show, to defeat that, to your point, show there's one white person in that mix, who is treated the same as the African-American. But I wouldn't have done it that way. I don't think it's necessary, because they're putting now the court in the position of having to say DC is racist. And there's no reason to do that. If they breach the contract, they breach the contract. Their motivation for doing so is irrelevant. And
it's a pretty clear-cut breach of contract action. I mean, assuming that the allegations are true, that there was one particular chief, and very well-known, well-respected chief from Seattle that came in, Chief Dean, and he came out with a memo that basically said, if you transfer or if you go through the fire academy, become a firefighter / EMT, you're going to have all the seniority, all the benefits of a firefighter, and everything's going to carry over. So it's pretty clear cut that there's a breach of contract. So why muddy it up with these other allegations?
Agreed.